Yes, Mr. Beltrami.
I was just working through the factual piece before we go on to the argument. We had stopped at the 12th of June, where Lehman sent draft 2 with tagging and
Yeah.
there was then a period of time when Alan Overy produced an updated regulatory letter, and there was contact with the FSA, and further internal consideration was given within Lehman as to whether, given their ranking, the notes were still debt rather than equity. The specific ranking point hadn't been resolved, or at least hadn't been concluded. If you can turn, please, to Supplemental Bundle 2, tab 41, page 5. It's an email on page 520, the 28th of August 2008. So it's several months after the draft, and just before, in fact, it was signed off. And it's from Claire Homer from Lehman. There's a number of people. And the context of this is that I think Mr. Grant had said, well, can you just check that with the amendments to the notes, they still remain debt rather than equity. And it went to Claire Homer, who was an expert in the regulation of the tax. And as you'll see halfway down, part of her consideration at that stage, even in August, she was giving thought to the seniority of the notes and the ranking position.
Sorry, where are we?
Sorry, under
tab
the heading,
41.
In terms of the floating rate subordinated notes.
Yes.
The fourth bullet point.
I'm sorry, I'm on the wrong page.
I think
No,
it's
520.
518.
Oh, gosh.
Was it 43?
Sorry,
so
no,
I moved on to 43.
No, it's entirely right. It's about
So I should be back at 41.
518 now. Do apologise.
518. So
Thank you.
under UK GAAP FRS 25. Is that
Just above that. Under terms of floating rate notes, subordinated notes, she was considering whether, pursuant to the amendments, they retained status as debt or equity. And one of the specific considerations given by Lehman at that stage was as to their seniority under the amendment. So even at that stage, Lehman was still actively considering what the ranking position was pursuant to the amendment. The idea that Mr. Phillips was all decided months ago is simply wrong as a matter of fact. The idea that it was ignored is wrong as a matter of fact. Even at this stage, we're looking at these notes to try to work out what ranking was. That was the time. And that was the end of August. And then, as I think we have been shown, can I just finish off the piece? If you go to 524, we then have the resolution and agreements authorizing the amendments. And the 524, there's the resolution of LBHI2, and you will see that it's a board minute, Mr. Rush and Mr. Jameson. Mr. Rush was Miss Dolby's superior in the tax department. Can I ask you to go to 522?
Yeah.
That's the LBHI2 board minute, Mr. Rush and Mr. Jameson. So Mr. Rush was the superior of Miss Dolby. He didn't give evidence. And Mr. Jameson was the corporate counsel. He didn't give evidence. It was for LBHI2 authorizing the amendment. And the way it was done for SLP3, if you go to 524.
Yeah. It was the resolution.
You've seen that, the written resolution signed by Emily Upton, who's the in-house counsel for SLP3, didn't give evidence. Countersigned by Mr. Rush on behalf of LBHI2. And so far as the ultimate approval for SLP3 was concerned, if you go to 528, electronic consent by the parent of the general partner of signed by Mr. Triolo, who was the sole general partner, on behalf of the sole general partner. He was a senior vice president in the U.S. tax department, involved with U.S. tax in the evidence, and he didn't give evidence. So, just summarising before we go to details, the points in the evidence was sparse. I mean, taking a look at make it through their substantive bits, one I can see. The evidence was sparse and largely built on such documents as there were, and clearly on reconstruction by the witnesses from those documents. That reconstruction was limited, given the fact that there were only two even potentially relevant witnesses, namely Miss Dolby and Mr. Brown. And given the passage of time, understandably, they're little independent recollection. So we simply do not know, the trial judge did not know, whether there were any discussions about any relevant matters by anyone else within Lehman, or what anyone else thought about ranking. None of that evidence was available. The only evidence was put through Ms. Dolby, and to some extent, Mr. Brown. That's the evidence. The drafting process, as I submitted for lunch, presents an evolution, dealing with different concerns at different times. I ended up dealing with interest deferral, tax, and consequential subordination. Those were the three issues that were. They were highlighted in blue and flagged for Lehman, which they were made well aware that those amendments were being made and the reason for them. And it was apparent in any event on the face of the draft through the blue amendments that the amendments were going much wider than pure interest deferral. That had been draft one. Very substantial amendments. That's the facts. And the judge set out the law on rectification for mutual mistake in his judgment 257-258. Since FSHC, we anticipate no sensible dispute about that. As the judge noted, the parties seeking rectification must demonstrate the relevant necessary standard of proof, the continuing common intention. As a result of a mistake, the document failed accurately to record. That requires convincing proof, which based the natural presumption of the written contract. And equally, and I'll come back to this point, where there's no antecedent contract, it's just a matter of common mutual understanding, the party must show the existence of a subjective common intention and that this is manifested by an outward expression of feeling. FSHC confirmed. I'll come back to the point. Now, from time to time, and sort of yesterday, SLP has sought to suggest that there's a dispute of law, I think, certainly before the judge, and I think now, contending that there's some lesser or different rule for amendments, exactly as to what you have to show. But that is wrong. It's simply a matter of evidence. It's also irrelevant given the actual findings from the judge. But I'll deal with that. On his judgment, paragraph 260, the judge dismissed the claims on three factual bases. First, there was no discernible intention by LBHI2 about relative ranking beyond that evinced by the object of construction. Secondly, equally, no discernible attention on the part of SLP3 beyond that evinced by object of construction. And third, no outward manifestation of accord in any way. So that's where the judge is now. As I indicated before lunch, I've got four headings, and the first heading is out of sequence in the sense it's the respondent's notice point, but logically the anterior, which is that there was no evidence at all about the intentions of the actual decision makers. Because clearly in any corporate question, one must first ask whose intention is relevant, but one then ask what that intention was. The judge indicated in his judgment he did not need to decide that point because he concluded there was no mistaken intention anywhere. So it wasn't necessary, and that piece of it is clearly right. But the logical first step is to say, well, hang on a minute, who are you even talking about here? And that's, the Lordship will forgive me to start with, frame the rest of it. Our primary position is that the rectification case came to court essentially on a threadbare, unprovable basis, because they simply never had any evidence as to the intentions of any relevant attributable individual, which in this context, in the context of rectification, means the decision maker. That's what one's looking for. The normal way to advance a case in rectification is by exploring the evidence of the attributable party. Ideally from oral evidence if you can. If not, it's still possible from other evidence, documentary evidence or indirect oral evidence from others, albeit at that point you're into inferences, etc. It's possible, but it's harder, but it's available. However, what one sees in rectification cases, as in fact in FSHC as commented, is the evidence being, quote, thrashed out in the witness box. We've seen that in several cases. FSHC, paragraph 38. And in that case, there are about a dozen witnesses that have been involved in the process. All of whose evidence was examined. And that's what the normal, I think it's the immutable position. It's the normal position of rectification, because one has to get the evidence of the relevant person. Turning it to somebody and saying, well, she'll do, it isn't a good starting point. So far as the test of attribution is concerned for rectification, it was most comprehensively explained by Mr. Justice Newey in a case called Murray and Hospitello, which I'm going to ask you to look at, which is Authorities Bundle 3, tab 56.
Tab
56. Can I ask you to turn to tab 56, page 1782? After reviewing the authority, including a number of Court of Appeal authorities, Mr. Justice Mann set out principles, paragraph 180, which I don't believe were disputed for the trial judge. And can I ask the court, maybe best just to read what the principles are?
I'm sorry, Mr. Beltram, you're dropping your voice every now and again. So which paragraph are you on now?
No, I'm not doing well so far. 198.
Yes.
So the principles A to E, can I ask the court to read the principles, which I don't understand to be in dispute, as a starting point for identifying the persons whose intention is attributable to the contracting party.
Yeah.
Well, maybe that window's open, but I'm quite happy for it to be open, but I'll have to shout.
Yeah, I'm afraid you're competing with the scaffolding. Yeah.
So, as you will see from that, the focus is on the person who is the decision maker. And that will usually be the person with authority to bind the company. It may be someone else, if that is the reality on the facts. And it may be possible to attribute the intention of a negotiator to Paul, either as because he's the actual decision maker in reality, or through some process of adoption, if it can be said that the actual decision maker adopted or shared the intentions of the negotiator. So that's what one is looking for in identifying the relevant persons. In that case, one of those cases where the facts are interesting, but I wouldn't trouble you with them. But the ultimate difference was between, in that case, the negotiators had a certain intention. The question was that attributable to ISIS, which was a counseling service company, and Hospitello, which was a trust company. And ISIS used corporate service providers, whose director simply turned up the day and rubber stamped a minute. And the judge said, well, hang on a minute, they weren't the real decision makers. The real decision maker was the negotiator who was doing the deal. Hospitello, the trust company, didn't do much more, to be fair, but had a bit more supervisory control over what happened. They didn't do nothing. They may not have done very much. And the judge said, well, maybe it was likely they would do what the negotiator proposed, but it wasn't inevitable they would do what the negotiator proposed. And that was the difference in that judge's view in that case. It really has to be, if one is moving away from the authorized decision makers, essentially an inert party. The corporate service provider who makes no actual decision at all, who just does what he's told in reality. As soon as you get into the position where the actual decision maker is making a real decision, then that is the person whose intention is attributable to the company. still means as a matter of evidence, one can say, well, that intention was adopted, or he adopted someone else's intention, but that's a matter of evidence. That's the question. Who is the actual decision maker? And what were the intentions of the actual decision maker for rectification purposes? And an example of the failure to provide evidence to answer that question can be seen in the George Wimpey case, which is Authorities Bundle 2. Tab 30, page 653. Through page 653. This was a case where a dispute had been negotiated for Wimpey by Mr. Kerridge, but Mr. Kerridge had no authority to contract for Wimpey. The contract was approved by the board and executed by Mr. Hewitt, the solicitor. There's a case, in fact, of unilateral mistake, but nothing was done on that. The problem for Wimpey was that whatever Mr. Kerridge's opinions or intentions were, they hadn't brought to court evidence of the decision makers, namely the board members who made the decision in order to contract. And if you go to page 664, you can see the problem. At 48, maybe I can actually read 48 and 49.
Yeah.
Clearly, every case must turn its own facts, and I can't say that for that purpose. But it's an indication of what happens if you come to court in a rectification case without the right people. You don't have the right decision makers. You can't provide the evidence of what they're in, or you're not likely to be able to provide the evidence of what their intentions are. And it doesn't work to say, well, we've got somebody who has something to do with it, so that person will do instead. One always has to focus on who the decision makers are, and then ask, is there evidence sufficient for rectification for their intentions to be established?
And there could, I suppose, have been evidence from Miss Dolby to say, well, the board always do what I recommend.
Well, I'm going to take you to evidence in this topic. There could have been. That's what I'm saying. You can get there by through other evidence, if there isn't such evidence. I actually said the opposite. So the immediate difficulty, before we even get into any of the details, facing SLP 3 is that the starting point for Mr. Justice Newey are likely to be the person for the authority to find. And here that was Mr. Russ, Mr. Jameson, Miss Upton possibly, and Mr. Fiora, and none of whom gave evidence. And none of whose intentions were therefore explored in evidence. The case on who the decision makers were has, to be fair to my friends, fluctuated a bit over time. In opening it was Miss Dolby and Miss McMorrow. In closing, the focus went on Miss Dolby. My friend's skeleton before this court, footnote 96, is the assertion that it's Miss Dolby and Miss McMorrow, with no detail at all, it's just an assertion. And yesterday the submission was Miss Dolby was a relevant decision maker. So one or both of those have been floating around as the relevant decision maker. The difficulty in asking the question, who were the decision makers? First of all, none of the authorized decision makers gave evidence. And none of them was able to explain, we just did what we were told to do. That wasn't before the court. Not conclusive, but that wasn't before the court. There was no evidence from Miss Dolby or anything more wasn't there. No evidence from Miss Dolby that those were not the true decision makers. There's no evidence that they delegated their role to her, or didn't operate it properly, or just acted as a rubber stamp for what she, in her role in the tax department, was working on. And such evidence as there was contrary to that. If you can go to supplemental bundle 2, tab 54, page 568. This is Miss Dolby's cross-examination. Pick it up at 113, the top left. Maybe I'll show you. Can you read page 113 and 114? As to the process within, as one might expect, by the way, within Lehman, how decisions were made. These decisions were made through committees, through departments, and all the way up to the board, who would then question them or focus on them as appropriate. And Miss Dolby was one cog in the process in the tax department. But this is not a process, we would submit, where the authorized decision makers can be said to have delegated the decision-making role to somebody in the tax department, contrary to what she describes there. But more than that, she gave incontrovertible evidence, and the reason it's incontrovertible, I explain, that in terms that she was not a decision maker. Her role was she was second in charge in the European tax department under Mr. Rush. And tax was just one department involved in these complex structuring. She was asked several times whether she was a decision maker, and each time she denied it. This arose before the evidence of the trial. Miss Dolby had been interviewed through I think some common agreement between the parties, an informal interview between the parties. The content of the interview was adduced by SLP 3 by way of civil evidence activities. So it's their evidence which they advanced to the trial judge. It's their evidence on this interview. If you can go please to supplemental bundle 1, tab 4. Page 59. Page 59, we pick up at line 20. Asked, did you make the ultimate decisions for any legal entity? I wouldn't make the ultimate decisions about a project involving legal entities. I present it to management, and they would make the ultimate decision. Over the page, line 4, I wouldn't be saying you should be doing this, I've done this transaction, you should be signing off. I'd be saying this is a transaction tax related, you've already been aware of it, you say to me periodically, how's it going? And then the question is, presumably the transaction involved more than just tax related matters, the ultimate decision would require appreciation of a range of different things. Yes, and tax would be just one of them. So she was one department in the process. And if you then go to 61, she asks again, line 3, I wouldn't say I made the decision, I would have proposed the structure. Someone higher than me, management or director, would have made the decision, we're going ahead with the structure. Now that, let's say, was SLP 3's own evidence. Difficult, we would submit, to maintain a case that she was the decision maker when their own evidence was she wasn't. And once that's gone, as it must have been, we're left with the argument that the decision makers, there must be evidential argument that the decision makers, being Mr. Triolo and Mr. Rush, must have just adopted her intentions, because that's all that's left from Mr. Justice Mann's analysis. Either somebody else's decision maker wrong, or they're the decision maker but they adopt the analysis of someone else. So it's an evidential route to get there, but there was no evidence in support of it. They didn't give evidence as to whether they did or did adopt anything Miss Dolby said. So one couldn't conclude it from what they said. And Miss Dolby, as we said, didn't suggest they just adopted her intentions. They suggested, she indicated she was part of one department. The decision makers had to deal with everything, and the decision makers made their own decisions. So she didn't say that they just adopted whatever she thought. The actual evidence from the passage I took to your lordship and ladyship to the judgment is that Mr. Rush played an active role, asking questions and dealing with issues. As far as Mr. Triolo is concerned, there's simply no evidence at all as to the circumstance in which he came to sign the document. If you still in this interview note, if you go to page 55, this is still Mr. Alden. Still SLPP's evidence. And remember, of course, they have to adopt the intentions on both sides of the transaction. 23, she's asked about Mr. Triolo, and 26, is it likely that John Triolo would have signed the consent on the basis of what was described in it, rather than requesting separately a copy of the amended document? I can't really comment on that. I wouldn't know how he went about authorising this. He might have requested it, I wouldn't know. So her evidence, i.e. SLP3's evidence, is she did not know what Mr. Triolo did and didn't do, and he came to sign this document. So there's no evidential basis in which the court could have concluded that Mr. Triolo adopted her intentions, and her own evidence was she didn't know what he did. And all that's left from all that, the residue which we got yesterday, was that Mr. Phillips extracted in cross-examination a statement from Miss Dolby that Mr. Rush shared her intention that the amendment was to defer interest. Mr. Phillips took me to it yesterday, page 571 of the bundle, that Mr. Rush shared her intention. But that's, at best, evidence that he understood the origin of the amendment, and no one disputes that he would have understood the origin of the amendment. What it isn't is evidence as to what he understood that the amendment actually did in terms of ranking. Whether he had any understanding at all, whether he had no understanding, whether he understood it rightly or wrongly. There has never been any evidence of their intention. And in the absence of any evidence of their intention, this case in rectification was never going anywhere.
What was the basis of Miss Dolby's acceptance of the proposition that Mr. Rush shared the intention? Was she give evidence of some conversation between them?
Well, she did indicate that she spoke to Mr. Rush about this from time to time, but all that evidence meant was, well, if you looked at the board minutes that said the purpose of this is to defer interest, of course she would say, well, yes, he knew the purpose was to defer interest. That's as far as it goes. It says nothing at all about what he actually thought about these amendments.
But I think she does say, or the question put to her on page 571 is, and you did not discuss ranking alteration with Mr. Rush, that's right, and she says yes.
Yeah. So she had no way of knowing what he thought about ranking. And she had no intentions communicated about ranking to him. So no, that's why I started with the attribution point.
Yep.
The next stage is, all right, assuming somehow we get through that, and the question is there a mistake? It has to be Miss Dolby or possibly Miss McMorrow or whatever. I mean, frankly, one of the many difficulties is if anybody's intention other than the authorised directors was going to be relevant, one would assume it would have been Miss McMorrow of those two because she was the legal counsel. So she might, in theory, I suppose, have some relevant intention one way or the other. But she didn't give evidence, so she's kind of out of the picture. So we're really left with Miss Dolby. So the second question is, was there evidence, or ought the judge to have concluded on the evidence that Miss Dolby had a mistaken intention about ranking? said earlier, the judge found as a fact that the parties had no intention other than to signing up to the amendments, whatever their objective construction was. The judge was able to assess Miss Dolby's evidence, of course, and conclude that she therefore had no relevant mistaken intention. He was certainly entitled, when we submit right, to reach that conclusion for several reasons. First, because it's quite clear, and I don't even think it's disputed, she had no relevant intention as regards ranking. This being something which, on her evidence, to which she gave no thought at all, either before or after the amendment. She had no relevant intention either way, and she had no knowledge of whether anyone else had a relevant intention either way. The reason for that, two reasons for that. The first is that on the evidence, no one in Lehman thought this would ever be relevant. It would never be relevant, A, because no one thought Lehman would collapse, but B, if they thought about it, no one thought that if it collapsed, subordinated debt ranking would matter. I'm not sure how many solvent administrations there have been, but this is such an unusual circumstance. That's why Mr. Phillips, this is a fundamental change in so material sense. It was nowhere near anybody's radar. So that's the first reason she gave it no thought. Never thought it would be right. The second reason she gave it no thought, it was not a matter for her. It had no tax implications. It wasn't within her department, which is what she said repeatedly. If we go back to the interview, and go back to page 39, please.
I'm sorry, you're going to have to give me that again. I think I put it away.
The interview, it's tab 4, page 39.
Thank you.
So from line 20 on page 39, she's asked, was the potential ranking, line 20, was the potential ranking of the debt in an insolvency a factor in choosing the interest rate on the note? I wouldn't have been involved in interest rate. Treasury would have just told me what was the appropriate rate. I can't comment on that. And then she says, 27, the ECAPS issuance was initiative led by the Treasury team. I was involved in the periphery because I think the benefit of doing it was that we ended up getting a tax deduction. The initial issuance I would have been involved in from a tax perspective. But other than that, I didn't really get involved post the confirmation of the tax treatment. And then if you move on to page 40, line 23. She's asked about the AO opinion for the purpose of the waiver application, and asked at 26, do you recall there being any discussion about the ranking or prioritization of the PLC subject against other debts? I don't recall, but I wouldn't have been involved in those discussions, I don't think. If there had been discussions like that, who would have been involved? The Reg guys and the Treasury guys. This wasn't even a matter for Ms. Dolby. And then over the page, did you personally have any expectation as to how the notes and debt would rank against each other? No. Was there any consideration to your knowledge of the respective ranking? I've got no knowledge of that. And line 12, that would be a regulatory requirement. My regulatory colleagues would have instigated that. I wouldn't have had knowledge of it or been involved. If you go to 61, page 61, line 16. To the extent you did advise people, was that advice tax related or limited to tax advice? Yes. And then 72. Line 6. I was asked about ranking and really think about it. And he says at line 6, subordination and ranking wouldn't have been at the forefront of my mind if it was in my mind at all. You recall thinking about subordination. I mean, that it wasn't tax. Tax weren't interested in that. that would have been a regulatory and potentially treasury, but it wasn't a thing that we were interested in. So, just to recap, the sole person being put forward to the court, the relevant person from mistaken intention, had no interest in it. It wasn't her department. So, when you go back to the cross-examination, Mr. Phillips took you to, that she only intended to defer interest. Of course she did. That was the only tax bit that she was interested in. But ultimately, it's to say no more than, and this is as far as they've managed to get in the evidence, she was not concerned with something she was not concerned with. That's the problem. So we submit she self-evidently made no mistake about it. It also illustrates equally why the case that she's the decision maker simply can't stand up, because she's got a narrow silo of interest. She's not a decision maker across the piece. She says that herself.
Right, next point.
Next point. More broadly, on her evidence, that she was content to leave the drafting to Ellen Overy, even assuming she was somehow relevant and all this stuff. And that, what has this, but it's the witness statement, supplemental bundle 1, tab 5, page 80. And there was no challenge to this evidence, where she said, she had no particular reason to second guess that drafting. Ms. McMorrow would have been reviewing the documentation, would be happy with the process, which I now for execution. Now, she didn't say, and Mr. Phillips made this point, it doesn't matter, that she just never read anything and just left it all to somebody else. But what she did say, we submit and not challenge, was that she was not going to second guess, wasn't going to go down every clause and paragraph in their amendments, work out exactly what it was and what it achieved and whether it achieved the purpose that she wanted to do. To that extent, she was prepared to allow Ellen Overy to draft the provisions they considered needed to be drafted and to proceed on the basis that they were the right provisions for Lehman. And that is what we say is a very commonplace approach to any corporate institution having drafted documents. It could never be a position in rectification that as soon as you identify a provision which the client didn't interrogate, somehow that's a mistake. There must always be a process by which a client is able to leave it in the hands of the lawyers and bears the consequences of doing so.
Depends, doesn't it? I mean, if you instruct your lawyer to do A and he does A and B, you might be able to say that B was a mistake.
Your Lordship is absolutely right, and this is the point that I think your Lordship made and we made, and we can come back to it. On one view, the case really being advanced, the case of authority. It's not called that because it can't be a case of authority for all sorts of other reasons. But in one sense, the real case being advanced is, well, we wanted to do X. You went off on a frolic on your own and did Y. You weren't authorized to do that. That has been the case in a whole different trial. For all sorts of reasons, it would have failed. But in a sense, that is what happens. That ultimately they complained. But there's no such complaint here. It's not alleged there's a lack of authority. So if there's no lack of authority and the client is prepared to go along with the drafting, you are only into rectification. We would submit that you can't be into rectification on those factors. So that was her positive evidence. It wasn't even an absence of evidence of her intention. Her positive evidence intention was that she was prepared to let Ellen Overy do the drafting. And that was what we submit assisted the judge in his conclusion that the only intention within Lehman was for the objective meaning of these notes. Now, third, going slightly out of the sequence, but third, the amendments weren't a mistake by Ellen Overy. Now, we must be a bit careful with Ellen Overy because no one suggested they were the decision makers and no one suggested their decisions were adopted. So in a sense, Mr. Grant's evidence is not actually evidence relevant to rectification. It might be background, but there's been no link up to Lehman for his evidence. But nevertheless, we know that they were specifically, the amendments were specifically and intentionally drafted by them after careful deliberation to resolve a particular problem which they had identified. It was a tax problem and a consequential subordination problem. So it was a deliberate drafting process to achieve a result which they intended to achieve. And from their perspective, that wasn't a mistake because they achieved the result that they intended to achieve. Now, there is a suggestion, and there was a suggestion in the evidence, that Mr. Grant didn't intend to change ranking. But one always had to treat that with a bit of a pinch of salt. And on his evidence, he didn't even know there was other subordinated debt. He didn't even know there was a ranking question against other debt. And he didn't know what the ranking position was about the other debt. He didn't know it existed. So for him to say after the event, I didn't intend to change ranking, isn't really evidence of fact, because he didn't know there was a ranking issue to be addressed. What he knew was there was a subordination issue to be addressed, which he addressed. And we say that didn't give rise to a mistake in his context, even of his intention.
Yeah, I mean, if you say, I've drafted this, but I didn't mean to change the ranking, I would expect the drafter to have had a view about what the pre-existing ranking was.
He didn't even know there was a ranking, because in his evidence he didn't know there was other debt. So one doesn't intend to, it's very difficult to grapple with that. And we do say, what he's actually talking about when he says I didn't intend to use. It's not that it's much the legal effect of the document, because the document is a document. The document subordinates, on my construction, subordinates the notes at a certain level. No mistake about that. That's what they do, and that's what we say he intended to do, because he drafted it so as to subordinate them at that level. What he says he didn't intend is, if you like, sort of factual consequence of that. It is that if you do subordinate at that level, some other debt might find itself above you. And that isn't a legal effect of the document. It's a factual effect if another document does or doesn't exist and say something. One has to be quite careful as to what this mistake supposedly is. In terms of what the document does, it does exactly what he intended it to do. What he says in his evidence he didn't know was the factual consequence of that, which wouldn't be sufficient for rectification. That's my third point, and an overview. Fourth point is, you sort of build up, but whether it's relevant. In contrast to some other cases, such as FSHD, the amendments can't be said to be overlooked by the union. Because that's why I took your lordship and ladyship through the facts. They were staring them in the face. They were all over the blue amendments. They were flagged by the union. And we have set out in our skeleton, we don't need to fill out 93B, all the people in Lehman we identified who saw them, because they were recipients of a number of emails. And we know that email I showed you from August, they were specifically looking at the notes in order to decide a tax issue by reference to ranking. So it can't be said it bypassed the union. The documents were there in their face and flagged. And we say again that is inconsistent with the idea of rectification. And the fifth point is the judge's finding that not only was this a matter never discussed, but that had it been discussed, it would have been regarded as a matter of indifference to the parties. And if it had been raised, it would have been dismissed as irrelevant. And that's judgment paragraph 262. That finding, I know that finding is sought to be challenged, that finding by itself, we submit, is fatal to any case of rectification. One thing to say, well, it wasn't discussed. We submit that isn't nearly enough in the facts of this case. But if the conclusion is, even if it had been discussed, it would have been dismissed as irrelevant. It is, we say, impossible to conclude there was a relevant mistake. There is no case remotely similar to that. Mr. Phillips did describe it as a fundamental change, but the judge finds the fact it would have been a matter of indifference. You say it was perfectly entitled to make that, having heard all the evidence before him. In particular, in light of the regulatory indifference, no difference to regulation. Clear evidence was never discussed because no one ever thought it would arise to be relevant. Evidence that the amendments were flagged, but nobody thought, does that create a problem? Evidence that able to say that it would have made a difference. The highest it went, if you go to Miss Dolby's witness statement.
Well, she says she would have discussed it.
Yeah. Well, yeah. She would have discussed it. But where does that take you on the discussion? But the judge's finding is that even if you discussed it, it would have been met with indifference. Nobody was able to take that next stage that had it been discussed, we would have done something about it. So there was an absence of evidence of that critical bit. They would have discussed, I think in fact it was may have discussed, doesn't suffice, or doesn't amount, or isn't sufficient to challenge the finding of indifference. And the final point, just going through the facts, we know this was a deliberate change by Alan Overy for a deliberate tax purpose. So on that hypothetical, had it been raised, one would assume that Alan Overy would have explained why they had done it. And in circumstances in which no one in Lehman thought this issue of ranking was of any relevance at all, the judge was perfectly entitled to include. The conclusion would have been, doesn't matter. And also don't forget that because of the in-person, one mustn't forget that that this rectification claim, back to the point I made, is for the whole of clause 3A. The whole thing has to go. So Manifest hypothesis has to be, the judge ought to have concluded, had this been raised, Miss Dolby would have discussed it with somebody. Somebody would have said, get rid of the whole thing. It wouldn't be enough for them to say, just change the ranking condition, because that's not the case. The case has to be, the whole baby has to go out of the garden. Even though Alan Overy is saying, there is a tax issue which we are dealing with. Now, that is so far removed from the evidence.
Yeah.
That there is, with respect, no basis at all to challenge the judge's finding, so what? If they can't challenge the judge's finding, so what? There can't be a case in rectification. Final point on this is that there is essentially a single theme running through much of SRP's case on rectification, which is that the change in ranking didn't fall within the supposed purpose of the amendment, which is namely to defer interest and reference to board minutes, etc. Yeah. There you are, that's the purpose.
Well, I think you've been over that, haven't you?
I think I can do that. Can I just show you his point, on the face of it, a lot more than that. We know from the evidence a lot more than that. Mr. Grant confirmed in his evidence it's more than that. Let me just give you that piece which you don't know, which is Bundle 2, Supplemental 2, page 549.
Do you have a tab number?
Tab 51.
51. Yeah.
And it's on the right-hand column, specifically asking the bit about these documents. And from that line 9, that was a reference.
Sorry, which page are we on?
Sorry, top right.
Which page?
So 1, 2, 3. Miniscript page 1, 2, 3.
1, 2, 3,
549.
yes. 1, 2, 3, top right. Sorry about that. Line 9. I'm asking about one of the documents. I think it was the board minutes or one of the other documents. So these purpose documents. That was a reference to the initial driver of the notes rather than being an exclusive statement of all the purposes of the amendments. Yes, that was a reference to core commercial change that was being made. The core commercial change wasn't a comprehensive statement. And then the answer was, that's right. In a sense, a statement of the obvious. We've seen that in the evidence. But to try to mount a case now, there should be rectification because there was a single purpose. It's first of all not consistent with the evidence we looked at, not even consistent with the Grant's evidence. This was nothing more than a statement of a purpose. So the conclusion from all of that is that in terms of intention, the judge was entitled and right to find that there was no intention beyond the object of the inferences. And therefore there was no mistaken intention, even if Miss Dolby's intention is a relevant intention for this purpose. Third point, no outward manifestation of accord, and all these are independent objections. FSHC confirms the absolute requirement, an independent requirement, the outward manifestation of accord in order to support a common intention rectification case, and that's paragraph 176 of the Lord Justice Newey judgment. and the judge had a separate conclusion that there was no such outward manifestation here. The contention from SLP3 is that that requirement does not obtain in this case, because this is more like a pension case. And as Lord Justice Leggett explained, there's a special rule for unilateral documents, starting with unilateral documents, moving into pension documents, where a unilateral document clearly just has one intention is important. In pension type documents, what Lord Justice Leggett said, in detail, is you still need a common intention, but there doesn't need to be an outward manifestation called. In circumstances which it's a sort of hybrid document, where one party, the trustee, has the power to amend, and the other party, normally the company, can only consent to it. So it's not really an agreement contract as such. It's a sort of hybrid document where there's a power to make an amendment subject to a right to consent. And that's what is explained in FSHG as why those type of documents don't carry with them the requirement of outward expression to a manifestation. So it's enough if they both have the same intention. They don't necessarily have to share that intention between them, because it's not quite a contract, it's something in between. What's sought to be alleged here is they're in that category. They're in the pension type document rather than a contract type document, and therefore they can avoid the need for outward manifestation. And that takes us to clause 12 of the notes. We can pick that up, if we may, core bundle 3, tab 41, page 728. To be clear with this, before we go back to this clause, we submit this argument is entirely wrong. These notes are commercial contracts. Of course they're commercial contracts. They're multilateral commercial contracts between the issuer and the note holders. And we say, in fact, a regular species of commercial contract. Any amendments to such an agreement, subject to one point I'll show you, in the normal way, requires the consent of both contracting parties, as with any other commercial contract. And therefore, we're full square within the normal rule, as per Lord Justice Leggett, as a manifestation of clause contract. The reference to clause 12a is nothing to do with this clause. The reference to 12a concerns the means by which the note holders are deemed to agree. So sometimes they call this a cramming down provision. I think Lord Justice Lewison referred to this. There could be 100% note holders agreement. Pursuant to clause 12a, if there's a reserve matter, there could be an extraordinary resolution, which requires, I think, 75% of whatever it is. I think it's 75%. But the purpose of that is to say, not all the note holders have to agree. They can still be bound if the relevant majority agrees for them. So their bit of the contract can be processed other than 100% agreement. So clearly, as a multilateral contract, everyone would have to agree in theory for any change. And what this provision says is that when you're looking at the note holders, you don't all have to agree. Some can be forced to agree if there's a relevant majority. And that's a matter of process within the note holders. But it doesn't say, and that will do the job. Because what you then have to have is the agreement of the issuer. And this says nothing about the agreement of the issuer. This contract couldn't be amended without the agreement of the note holders and the issuer. All this does is say what will suffice for the note holders agreement. You still need to have the agreement of the issuer. And that's why this is still a normal contract. This is why there's nothing to do with the point of what Justice Leggett made. This is not a contract which can be changed by one party to which the other party has to consent. This is a contract to which both parties have to consent. And clause 12a indicates how a note holder can be deemed to consent. There's nothing at all about the issue. So it's completely irrelevant. Now, the only other issue, and in contrast almost if you like, is 12b, just over there. And that provides for some circumstances in which the registrar may without the consent of the note holders, agree to a modification in limited form. So there's some process by which a registrar can effect an amendment, essentially, as you might imagine, not specially material. And so that is, on the face of it, something that wouldn't have to be done by agreement. But we're not in that territory at all. What we are in territory here is an agreement to defer interest and to make other changes to the notes. And we submit there's absolutely nothing in clause 12 to suggest that an agreement should make that amendment would not require the consent of both contracting parties in the normal way.
And the registrar, I wondered if this was something to do with company's registration or stock exchange registration, but it turns out to be Lehman is a registrar according to definitions.
Well, I hope that wasn't the cause of all the problems, who knows? But anyway, there's a small facility to make minor changes unilaterally, but there's no suggestion of unilateral amendments.
No.
It's just a process by which note holder agreement can be crammed out. So because of that, we need an objective manifestation of clause. Just to pick up one point, another friend also says, well, if you look at the resolution, it uses the word consent. The SLP3 resolution was consented to by LDHI2 as issue. But you use whatever wording they use, it doesn't affect the construction of the agreement, which is the multilateral contract requiring the agreement. Now, if I'm right on that, the question is, was the judge right to conclude that there wasn't an objective manifestation of the clause? The only documents that are relied upon in support of the objective manifestation of the clause are those documents for that purpose. So we go around this.
Yeah.
So if there was such a requirement, which plainly there was no objective manifestation of the clause from the judge's finding. It's quite right. So that's my first point. My last point, which I know the court has, is I say last point, I'm going to respond. The claim collapses under it. It's simply, it almost proves too much, such that it's impossible. The only claim to rectification for the judge was the one that the court now sees, to remove virtually the entirety of clause 3, as proposed in draft 2, and essentially to restore draft 1, so the one goes back to the 5th of June in the SLP case. There was never any alternative case, but to succeed on that case, the submission has to be that Lehman's actual intention was that the entirety of clause 3 should have no legal effect, i.e. that the whole exercise was a mistake. There was a mistake to include Mr. Dehow's tax changes and a mistake to include Mr. Grant's consequential ranking changes. But there is, we submit, no possible basis, even on the most favourable interpretation of facts, to rewrite the tax changes. And indeed very dangerous now to do so, to restore Lehman's position and expose them on the face of it to a potential tax problem, which they resolve through that process. Now, in any event, it can't be characterised as a mistake. It was specifically intended by Helen, specifically flagged for Lehman. And it was for a particular purpose, not even alleged at trial to be erroneous, let alone established at trial to be erroneous. And would be simply an impossible conclusion in a rectification case to throw out the whole of the clause. But on the assumption that the tax changes must fail, the subordination changes must fail, because those were specifically intended to resolve the subordination problem consequential on the tax issue. The real case, if they could go over everything else, the case which they ought to have advanced is not the case which they did advance and refused to resolve, but that somehow clause 3 should be rectified to have a sort of saving provision to say, well, nothing affects subordination against other debt or something like that. I don't know. Some sort of provision which could preserve the tax provision, possibly. We don't know if it would or wouldn't preserve the tax provision, of course. That would be another discussion. But some provision to deal with the ranking problem and preserve all the rest of it. That, in a sense, is the only, frankly, credible case that could have been conceived. It hasn't been advanced, so we don't have to deal with it. It appears to us it probably hasn't been advanced it's not really consistent with their purpose case. It seems that they wanted to run the purpose point. Look at the board minutes. The purpose was deferral of interest. Everything else was to be rectified. It seems to be that's why we are where we are. That point doesn't work for the reasons I explained. We are left with sort of monster, which simply can't reflect the evidence. So that's my fourth point. It just breaks under some information. Now, can I now deal the grounds of appeal, or the arguments in appeal in relation to the rectification case? And maybe if we can pick it up, there's from Merton Skeleton, which is CD1, tab 7, page 91, core bundle 1.
Where you've already given your answers to these points, you needn't go over them again.
No, I shall certainly try not to do so. 101, the first complaint is the judge failed to consider relevant evidence, to which we say, well, this couldn't possibly be assessed on the ground of appeal. He simply considered the evidence wasn't enough for rectification. He was perfectly entitled to do so. He didn't set it all out. Had he set it all out, we'd have a longer judgment with the same answer. So that's not a ground of appeal. The second objection, 107, what is about intention, and this raises one legal issue which I'm going to have to just deal with at some level. Begins at 107 of the skeleton, and as we see it, it's a factual challenge which almost may look like a legal challenge. But what you have to prove for intention, particularly for amendments. Now, it's clear as a matter of law we submit that rectification is possible only where the written contract conflicts with the terms which part of the parties positively agreed. It's not enough that the written contract provides for something they didn't agree. So it has to be a positive conflict as opposed to dealing with something they didn't agree to because they didn't discuss it or forgot it or whatever. And that is, we say, clear on the authorities. If you go to, first one is Lloyd and Stanbury, Authorities Bundle 1, tab 6. Page 89. In this case, it's a sale of land by reference to Ordnance Survey plots, and it included a plot which the vendor claimed he intended to retain, but was included by mistake. And the question was whether there was a right to rectify that on the grounds of mutual mistake. And if you go to page 97, Justice Brighton explains what needed to be shown for the rectification case. And at 97, letter F, if the defence of rectification is to succeed, I must be convinced there was not the intention of either party that the plot should be included in the contract. It is not sufficient that there should be convincing proof the written contract didn't represent the true intention. It must also be satisfied there was a common intention which should be excluded. There's a difference between not thinking about it and having a positive contrary intention. And one can see that as it then played out in his analysis over the page on 98, the top of the page, talking about the purchaser. I think Haidam Laki was interested in the question of precise boundaries. He was content to leave the exact location to his legal advisors, and he didn't have the least idea who was going to be owning the plot. So this is a classic case where one party had not thought about the plot. That wasn't enough. They both had to think it wasn't included, as opposed to they both had to think. Can I now take you to a more recent case, which is Ralph and Ralph, Authorities Bundle 4, tab 68. slightly unfortunate case in many ways. It was a claim to rectify the land registry form where parties had ticked the box for tenancy in common. In circumstances in which, if you go to paragraph 1, the question is whether a land registry form signed by the transferor, but not the transferee, to be rectified to remove a manuscript cross from the box. On the grounds, I said in the paragraph, the trial judge held the evidence no such thing had been actually agreed between the parties.
They didn't agree that the manuscript box should be crossed.
Yes, that's the problem.
Yeah.
They hadn't agreed anything about it. Is the problem. If you then move down to paragraph 3, and then just over the page on 2337, the judge is finding entirely satisfied. It was never intended by either party these should be joint owners in equity. They didn't intend to be joint owners. And at paragraph 7, the appeal, I think the judge granted rectification. He said the main ground of appeal at paragraph 7 was inadmissible with no positive subject of common agreement between them and no sufficient outward expression of the court. I.e. they hadn't actually agreed anything. And the way it was then dealt with, if we move down to paragraph 34, not necessarily decide whether the need for outward expression of the court. That's because it wasn't a normal contract clause. That's because, as I see the facts found the trial judge, he did not find any continuing common intention at the time of completion of the purchase as to beneficial interest of each was to hold. So the absence of an intention was inadequate. And then 37 concern. There's no suggestion at these findings the trial judge thought it had been proved that a continuing common intention of property should not be held for themselves in equal share. Most that can be said is the trial judge found they had not agreed the property should be held in equal share. So, kind of harsh, but rectification is harsh, and it means it, and we know that. But clear exposition of the need for a positive contrary intention as opposed to no intention, which ends up inconsistent.
I have in the back of my mind that there's a case called Kemper-Neptune Concrete, which says something along those lines. I think it's a decision of this court, probably in the 70s or 80s.
We can try to dig that up. If we just go back to 35, it feeds in with the point of FSHC. In discussing this difference in positive intention and absence of intention, the reference to FSHC, the deeds would only provide the missing security. And there's an ambiguity, or it may be an ambiguity, the word only. The idea was that was only that and nothing else. Now, that's the rule. There's no different rule of law when dealing with amendments. There's no special rule of law rectification. You need to prove something different when dealing with amendments. However, we accept that it must be right, that in any case of rectification, the court can infer an actual common intention. You don't have to have direct evidence of such. You can infer it from the evidence that you have. That's what you're looking for. That's the test. But the court can infer it from the evidence. And equally, we accept that in the case of an amendment, a clear positive intention to make one change might be evidence in support of a finding that there was an intention not to make a different change. So it's evidence, and it's capable of being inferred. And maybe in an amendment, there's a greater run at it, or things equal, than in a fresh contract from the start. But that's not a matter of a rule of law, it's just a rule of evidence as to what one gets from the material one has. What is important is what we're looking for, the actual positive intention. Now, if one goes back now to the skeleton, core bundle 1, tab 7, page 89, two complaints, the two contentions, and two principles. The first one. Two propositions being not to include the point of circumstance where the judge himself specifically notes and knowledge towards the employee pension scheme. Paragraph 93.
92,
93, sorry.
93.
93. Yes, these are two propositions. Following principles that you ought to apply these principles. And the first principle, 93.1, is it said, if decision makers had a subjective intention only to make a specific change, it, quote, necessarily follows that they didn't intend to make a further change, the first proposition. And the second proposition, 2, if change X has been the subject of discussion, the absence of discussion about Y may be evidence that parties didn't subjectively intend it. Now, I quarrel with the first one. That's not, when it says necessarily follows, it sounds like it's supposed to be a principle of law. It can only be an argument about evidential significance. But it's only ever, in the way it's framed, a circular statement, because it all depends on what one means by intention only to make a specific change. And this is where one gets into this semantic debate about purpose, etc. And as we said in our skeleton, there is a difference between you intend to make change X, and you intend to make no further change, or you intend to make change X and you're indifferent to further change. And that's the difference. And both of them can conveniently describe as you only intend to make change X. That'd be a different analysis. And we say it didn't really matter in our case because the judge found they didn't intend only to make change X. And on the evidence, they didn't intend to make change X because there were other changes in the face of the agreement which they must have intended. But even if they had got that far, and even if they had established only intention to make change X, that's only half the question. Because the real question is, do you intend to make change Y, or are you indifferent to make change Y? And again, on the judge's findings, they had no intention in relation to change Y one way or another. So we're back into these cases where there's no intent. At best, on the claim on SLP3's case, we're back into these cases where there's no intention. So that first proposition doesn't advance the argument. The second proposition is a matter of evidence. We accept that discussion may assist the inferences to be drawn. But the trouble is the judge didn't draw those inferences. And he's the inference. So that's the response to that. We do say that this case stands in stark contrast to the cases that were referred to in the friend skeleton, where inferences were drawn. And I won't take you to them because it's all different facts, etc. But in both of, for example, AMP and Barker, the pensions case, the evidence was they would never have agreed this. The evidence was it made a massive difference. They agreed what they intended to amend was something which would have a minimal financial impact and in one view might have benefited the fund. The consequence of the amendment was the acquired liabilities of something like £30 million. And the evidence was, had they known that they obviously wouldn't have done it. So it's a different scenario when one infers intention not to make change Y in that sort of circumstance. Similarly in FSHC, the facts were extraordinary. They intended to complete the security by putting in one piece of a security arrangement which had been agreed in an earlier transaction and they'd forgotten to complete. The intention was to put in that one piece of security in order to fill what they already agreed. They did it by way of accession deed. The accession deed also lumped in a lot of other liabilities. And all of a sudden, the whole business was under threat because they lumped in liabilities which they'd never agreed to do. It was called absurd, commercially hopeless, and all the rest of it. Again, they'd never have touched it with a barge pole had they known that was the consequence. So those are the sort of fact patterns where one can infer from an absence of a discussion an intention not to make change. But they are all extreme situations where it's obvious that the party concerned would not have agreed to the change had he known it had been made. And that goes right back to the judge's finding about so what. This is why so what. So fatal to so much in this case.
Yeah.
As soon as you're in that situation, you're not as interested. So that's all that. No, I think that one then goes to nearly finish at 112 of the skeleton.
Paragraph or page?
Paragraph 112.
Yep.
It said there's a challenge to the finding of intention by reference to factors relied upon. And I think I have gone through some of these, so very briefly. At paragraph 82, it said that the judge's finding was contrary to Miss Dolby's evidence. But the reasons I showed you, it wasn't Miss Dolby's evidence. She was taxed. She wasn't concerned with anything else. She was content to leave the drafting to Harry Mobley. Something with no tax implications and no concern for her. 83, 85, and 85 seem to be points about purpose, which we've dealt with. 86 is a sort of trailer for the authority case, because it then said the sole instruction was to declare interest, but that's not the case that we're dealing with. That doesn't help. In fact, and I asked Mr. Grant about this, so I wouldn't ask you to pick it up. I asked him in the firm, he considered he did have a wider remit, as one would expect. Lord Justice Newey. On his evidence, he said, well, if I saw something that was a problem, I considered I was within my obligations to deal with it. So it wasn't a matter of constraint authority anyway. He considered quite rightly he ought to deal with a point which was available to be dealt with. But it's not an authority case, so that doesn't go into it. And 87, absence of discussion. Paragraph 116, the next challenge on appeal is the challenge to findings on so what, which I've dealt with. And paragraph 118 is a challenge to outward expression of form, which I
Thank you very much, Mr. Beltrami. Right, Mr. Laney, I think you're next. No repetition.
Indeed, which makes my submissions very short. I'm very grateful to Mr. Beltrami and adopted his submissions. In our skeleton argument, we had taken two additional points. The second of which was on rectification, paragraphs 14 to 22, and Mr. Beltrami's covered it, so I will say nothing further about that. The first point we said in our skeleton was a point that actually doesn't rise on our case. It was simply an answer to Mr. Phillips' submission that the factual matrix might be relevant if the interpretation wasn't clear. And what we said in that event is, first of all, the interpretation is clear for the reasons that Mr. Beltrami has given. And secondly, if it wasn't, the answer wasn't what the judge did and what Mr. Phillips proposed, which is simply, essentially, to not engage in a process of contractual interpretation, but rather to apply the Bromerin-line principles, which is, I think, what my Mrs. Henderson had in mind yesterday.
I'd forgotten the name of the case, but Bromerin was what I had in mind.
Exactly, yes. It was what the parties would have intended was the correct exercise, not simply abandoning the process of construction. Now, on this appeal, it makes no difference, we say, because the outcome is clear as a process of construction. But I will return to that in the context of the PLC appeal, where that line of authority is what we rely on. It's what we cited repeatedly, but wasn't mentioned at all in the judgment. So, my lord, that's everything I have to say.
Well, that's short and sweet. No repetition. Right. Mr. Arden next.
I've been given 15 minutes. I'm pretty sure I can do better than that. The position of the administrators is much as the court would expect. We're neutral as to the outcome on the ranking list.
You just want to know what to do.
We want to know what to do. We have, there are really just 2 points I want to cover now against that. We've obviously provided a certain amount of information relating to the position of the two estates. In a sense, the figures don't matter. They don't affect they make no difference to the outcome on the ranking issue. All one needs to know is that there is, in the case of the LBHO2 estate, a surplus. In the case of the PLC estate, maybe. and that in either case there's a shortfall, and that's it. That's all one needs to know. We have in the skeleton just referred to some of the progress reports, and I think I just wondered this, and this is all I wanted to say on this point now. If the court thought that it would assist in terms of judgments to have just some headline figures which just show where the estates are, things stand, and where they think they will be.
Well, I think we've been told there's somewhere between 300 and 800 million for distribution, but that's way below the amount of the subordinated debt.
Things have moved. I mean,
do we need to know much more than that?
Not for the purposes of the exercise you have to undertake. It's simply that the figures are rather different.
Right.
It's somewhere between 800 million and a billion, subject to sort of costs, but there is a degree of uncertainty. So it's all gone up a bit, and there's a little bit more certainty, or the gap between best and worst has narrowed to a modest 200 million, but rather better than it was. If you think it would help for a section of the judgment or judgments, then we can do that.
Well, I think we can take the figure from you, can't we?
Well, if you just if you take the figures that I've just given, which is that.
Well, they're only illustrative, as you say. Nothing actually turns on it in terms of what we have to decide.
No, that's right. So that is in terms of realisations and potential surpluses. It's somewhere between two figures that I've just given. Of that, about 600 million has already been received, and of which about 350 million has been distributed already to PLC, but with the agreement of the two parties. So we have about 250 in hand. The rest of it will come from distributions most of the rest of it will come from distributions out of the Libya estate made to LBHI2 in its capacity as a member, and that's where the gap is, as it were, the uncertainty, and in respect of that, it's a 200 to 400 band, and that I think is probably that's probably what the first set of bullet points would have said. So if you're happy with that, then I'll take it no further. The other point I wanted just to raise now before I sit down, it just arises out of the difference between Mr. Phillips and Mr. Beltrami about the right way to approach the question of priority. And I just want to pick up on just tease out Mr. Beltrami's approach. Essentially, he may not entirely agree with the way in which I just summarised it, but essentially his submission was that this is all about ranking, focusing too hard on the right to proof and the scheme is the wrong way around. That what the court needs to do simply is to determine the question of ranking, and that's essentially a process of contractual construction. And then what follows from that in terms of the scheme is what will follow from the answer to the ranking question. So you don't invert it and say, is there a right to prove or is there not? You just simply say, who has priority over who, and then work out the consequences. Now, so far as my clients are concerned, I think we understand that. So I think essentially what is being said is you give effect to the ranking conclusion in whatever way is appropriate in the circumstances in which you find yourself. And so that might be, for example, by preventing a creditor, a subordinated creditor, from submitting a proof at all. In a sense, that's stage one of the waterfall one order, and necessary in that case to get over the logical problem that Lord Neuberger identified in the Supreme Court. You might not need to go that far. You might not need to stop it at that point. If a proof has already been submitted, you could give effect to the subordination agreement. An office holder could give effect to it by simply declining to deal with the proof, just putting it to one side and saying, well, I'm not going to deal with this, and so not admitting it. And that, in a sense, that's the second part of the Waterfall 1 order, where the order went on to say that the subordinated creditor couldn't require the office holder to deal with a proof. So assume it's been lodged, just simply don't do anything. Conceivably, an office holder would be justified in rejecting a proof on the grounds that it's simply premature. The other way in which it could arise, or another part of the distribution process where the question could arise, is in the context of distribution. And giving effect to a subordination agreement and to priority might, for example, almost certainly would, justify an office holder in not reserving for a subordinated claim in any distribution that's made until one gets to a point where you know that there is a surplus, so that it matters. Now, that I think is what I understood Mr. Beltrami's, or where his approach to this leads. That essentially you wait until you look at the circumstances in which you find yourself. The office holder does that, and then gives effect to the subordination, the ranking, in whatever way is appropriate in those circumstances. Now, I've teased that out because essentially this is the way in which the office holders will look at, well, what are we supposed to do in the circumstances of this, or indeed any other case? And as it seemed to me, listening to Mr. Beltrami's exposition, it was something of the nature that I've just described. You just ask the question, look at the circumstances, and there may be various ways in which the office holder should do it and would be justified in doing it. Now, I think really that is all I wanted to say. It's a sort of teasing out, it doesn't, not that Mr. Beltrami is right or wrong, simply this is where we think that submission goes, and goes so far as is relevant to the office holders in deciding how they should perform their functions, what they would be justified and required to do in the circumstances of a case like this. I think that's really all I wanted to say. Everything else is, I think, will be obvious, clear to the court and clear from the skeleton. So I don't think I have anything I can usefully add.
Thank you, Mr. Allen. Yes, Mr. Phillips.
Yes, my lords, your lordships will have seen from the timetable that despite my having detained your lordships until too late last night,
We're well ahead.
Well ahead. And I was wondering in the circumstances if we might rise now to give us a little bit of time to make our reply as helpful to your lordships as possible. I could, of course, do it now. I'm in your lordship's hands, but I haven't finished yet. Good grief. I could, of course, do it, but it probably wouldn't be as helpful to your lordships as it would be if perhaps we could rise now and I could start first thing tomorrow morning. But ultimately, I'm in your lordship's hands.
Right.
My lord, I've given up the time now because it's sensible for me to take the argument on Bromwood Island authorities and the PLC appeal. But I am quite tight for time there, and I've been limited on that and on partial release, both of which are quite heavy points. So having gone ahead in the timetable today, I was hoping to get a little bit more time.
Yeah. So, come round. I think we'd like you to carry straight on, please, Mr. Phillips.
Of course, my lords. Well, do forgive me if any of my points. Right, and forgive the fact that I've got a screen up because I've been making them on the screen, which is frightfully modern for me. Right, the first point that I wanted to deal with is the contingent debt point. And my learned friend, his submission was that Lord Newberger had not decided that the decision did not go to whether or not it was contingent. Lord Newberger did decide that it was not contingent, and the reason why that was critical to the case, never mind about the points around the outside, is that contingent debts can prove at any time and are valued. and the reason why Mr. Snowden argued in that case that the debt was contingent was because if the debt was contingent, then the debt proved, and then there was an argument that under the rules, because it was a debt proved, that the interest would be payable on the subordinated as well as the other debts, and that's the reason why it was run.
Can I just ask you this?
Yeah.
If I have a contingent debt, the rules say I can prove it.
Yes.
Can I agree not to prove it until
Of course.
Well, so why does it matter in the context of Waterfall 1, given that the decision seemed to turn on Clause 7, which both Mr. Justice David Richards and the Supreme Court interpreted as precluding a proof?
It didn't. Sorry, forgive me. It didn't only turn on Clause 7. Right. It turned on Lord Newberger's analysis that it wasn't a contingent debt, primarily because of the logical problems that gives rise to.
Well, I see that. I see the logical problem, but, well, all right. Yeah.
And that's what then led Lord Newberger to decide it wasn't a contingent debt. And I quite understand there's Clause 7 as well. I quite understand. But on contingent debt, that was decided in that case. And you can tell that it was decided in that case because of the changes in the orders.
Yeah.
Because your lordships in the Court of Appeal changed the order and expressly said it was contingent debt, and the Supreme Court changed it back and said in their judgments it was not contingent debt. And the point about, as I've said, the point about provability turned on it being a contingent contingent debt. The disagreement turned on it being a contingent debt. And with, if I may respectfully say, although there are the other points, that is the ratio. And my learned friend, with respect, is wrong in his analysis of the case. And the correct analysis is in that paragraph I took you to this morning in the learned judge's judgment.
Yeah.
And the reasoning of the learned judge, which, if I may respectfully, is correct, is that if a subordinated debt agrees to prove after senior debt, that of itself is an agreement not to prove until after the senior debt. And you do not need a separate mechanism. I quite accept, my lord, you could have contingent debt with a separate mechanism. But the shorter and the more important point is that, it's 2 points, is you can't prove because it is subordinated debt. And that's how it works. And as I've indicated, the line of reasoning goes back to MTC. And it's not contingent. Can I then, if you don't mind, just say something about Mr. Fuller and Mr. Fuller's book?
Yeah.
Mr. Fuller's book was not cited to the learned judge, and he refers to why it wasn't cited, because when we saw his draft judgment, we explained why it wasn't cited. And there were 2 reasons. One is particular to Mr. Fuller's position, is that he was the senior man in the Allen and Overy team, and he commented on the drafts in this case. But that was specific to him. But the intellectual one is actually more serious. Mr. Fuller's book, with the greatest respect to Mr. Fuller, is out of date and in many respects not accurate. His description in particular of how you subordinate by contingent debt is inconsistent with Lord Newberger's judgment. And it was out of date because, and sorry, I'll just say it. It's out of date because he didn't really come on board with what happened in 1993 in the MCC decision. Yes, it's footnote 50 in the learned judge's judgment.
So when the judge quoted from Mr. Fuller's book, that was his own research, was it?
That was his own research, and if I can put it this way, in my submission, it's highly regrettable because he wasn't addressed on it, and he did adopt an awful lot of Mr. Fuller's analysis. And at one point, and again, there's one point in the judgment where he is contrasting Mr. Fuller's analysis of the waterfall with Lord Newberger in Mortel. And with the greatest of respect, a textbook is no substitution for the decisions, in particular in this case, of the Supreme Court. And the reason why I say that is because when you come to deal with contingent debt, subordination, the Supreme Court is really where one should be looking. And I took you to Mr. Justice Weinlott's.
Sorry to interrupt. Can I just ask, because it's actually when one looks at the footnotes, there are many references to Mr. Fuller.
There are
paragraphs of Mr. Fuller's work. Was this point not raised when you got the draft judgment that you said?
Yes.
How can you rely on all this?
Yes, we did raise it, my lady, and I should, in fairness to the learned judge, show you footnote 50, which is how the learned judge dealt with it.
I'm sorry, I do recall that after all.
Related question, did the judge explain why he was placing so much reliance on Fuller? I have at the back of my mind, he may have said something about that. Maybe that's what it was going to take us to. If not, one slightly wonders where it came from, so to speak.
Well, do you mind if I just turn up footnote?
Of course not. I'm sorry. I didn't mean to ask.
No,
two
not
questions
at all.
Once. I thought maybe it might help.
I'm reminded, you probably know this, but the judgment was in draft for some months. I think it was about 3 months in all. But yes, we did raise the point. And of course, if it was a matter of interest to you, we would be very happy to forward to you what we said to the learned judge. But what he says is the parties were coy about, and he explains the reasons, and he points out the book is also 8 years old in its 3rd edition. And he says, I've elected to cite Fuller because it seems to me important to use, so far as possible, a common set of terms of reference to the concepts here in play. And one of the results, if I may respectfully put it this way, of having relied on Fuller is he picked up the similarity between my learned friend's submission and the description of contingent debt. The description of contingent debt in Fuller, and he's then gone with it. And one of the consequences is this contingent debt, simple contractual subordination analysis. And with the greatest respect to the learned judge, we do disagree. We do not. We have made our submissions. We don't think it's contingent debt. We do think you construe the clauses as a whole. It is a payability condition. It does not make the liability contingent, if I can put it that way, my lord. The two other points. First of all, this footnote was only added as a result of the submissions that we put in. And in my submission, it would have been preferable had a different approach been taken in relation to Mr. Fuller's books, as your lordships know. We just didn't debate it. But I do respectfully want to make it clear that in my submission, the question of whether or not Clause 5.1 creates contingent debt as opposed to has a condition as to when payment can be made is an important point of principle.
Well, you say it's been decided by the Supreme Court.
And it's been decided by the Supreme Court. And yes, and when I say contingent debt, I mean contingent debt in the insolvency sense. In other words, that qualifies as a contingent debt when you prove it. And I have not myself done an extensive trawl of other areas in which the description contingent might be used, but it may be that this is restricted to something of a term of art, if I can put it that way. But the point is, 5.1 is not a contingent debt. That was the decision of the Supreme Court, and I do respectfully submit that you should not construe this particular clause in those circumstances as a contingent debt.
There certainly are plenty of other contexts. I'm thinking of law of property and trusts, where there is a clear distinction between an interest which is actually contingent in the sense it doesn't arise until the happening of some event on the one hand,
Yes.
and interests which are give rise to a present obligation which is only dischargeable in the future on the other.
Yes, and
I mean, like an interest in remainder subject to a life interest, that vests immediately. It's not a contingent interest. Whereas if it's a remainder to the first son born to X or Y, that is purely contingent.
my lord, your lordship has the point, and the point in this case is that the liability is always there, but there are conditions that need to be met before it can be paid. And the reason, as your lordships have seen, that is done is to ensure that the subordinated debt is not paid before the senior debt, and that's where it goes to. And I'm reminded to say it's very much this is an insolvency law issue, and it's an issue my learned friend told you that he didn't think was terribly important, but it is important as a point of principle. So that was the first point. The second point, if I may, was my learned friend's submissions on the preference shares, because it was very cleverly done, but it's one of those occasions where you have to spot the joins, because what my learned friend's argument depends upon is the notes being placed in the waterfall at the level of a preference share, and therefore having a ceiling as well as a floor. Now, I'll develop this a little bit, but he described it as though it's a brick in the wall, and there it goes in as a preference share. And once it goes in as a preference share, you've got your ceiling and your floor. And my learned friend said, and I wrote it down, that preference shares have a clear and recognised place. That was my learned friend's language. However, the notional preference share in these the amended subnotes does not sit in the clear and recognised place in the waterfall that my learned friend identified. It does not clearly set a ranking by reference, to such a place. And if I can go back to the if I can go back to clause 3, which I'm sure you've got, is CB3 741. It describes a preference share which could not in fact be a preference share. And so you cannot take the well-known position of a preference share in the ranking or in the waterfall and say, from that, I can determine that that is where these notes rank. And the reason why I say that, and this is where the joins were, is that, as you know, it has a preferential right of return over, and it's, first of all, the holder of all other classes of share. And there's no problem with that. Preference shares having the right over all other shares is not a problem, and probably accords with my learned friend's description.
That's why they're preference shares.
Exactly, which is the well-known position of a preference share. But this is not in that position, because it is also over the notional holders. And the notional holder is a creditor. The notional holder is a creditor whose claims against the issuer are quantified as though they hold a notional share. And the notional share is notional unissued shares which have a preferential right. So, and we know why this has happened, but it is a creditor with a right over the preference shareholders, because the notional holder is a preference shareholder. If one looks at the description of the preference shareholders, of the notional holders, that's the preference shareholder. And it is a creditor with a right over that preference shareholder. And so the notes come in above a creditor. And that is not in the clear and recognised place of a preference shareholder. And of course, another thing that my learned friend did, I'm sorry, so what you get from this is what we've been saying throughout. It identifies above whom, but it does not identify below whom. It just identifies that they rank above a creditor who's above the preference shareholders. Now, the fact that there is a description of preference shareholder in this notional mechanism is neither here nor there. That does not pin them in that well-known place of preference shareholders. So you do not find the ceiling here in our submission. You just don't find it. And you do have to look at the rest of the clause. And that means that you look at the those in respect of whom the notes are subordinated, and they are subordinated in right of payment, as you well know, to the senior creditors as defined. And we've seen the definition of the senior creditors over the page, and I won't go through that again. That is below whom they are ranked. Now, we know why this mechanism has been used. It's been used because the upper tier 2 debt subordination type of technique is often done this way. And this was used for LT2, and so it was changed. And it was changed by putting a creditor in. So rather than the mechanism which says, I am treating you as if you're a preference shareholder, it says, I am treating you as if you are one rank of creditor above a creditor. And so from that, you just can't take the reference to preference shareholder as fixing in the ranking where they sit. Now, I'm not suggesting for a moment, my lords, that this is not relevant. Of course it's relevant. We construe the clause as a whole. But it doesn't tell you below whom. It doesn't fix them in that ranking by reference to a preference shareholder. And can I just make one other point? There was my learned friend throughout his submissions on this point referred to upper tier two subordinated debt holders as shareholders. That's not right. They could be preference shareholders, or they could be creditors, and that is clear from.
I think it's creditors with undated debt.
Yeah, then my lords, you've got the point. You've got the point. But I did notice that language.
No, I think Mr. Beltrami said that. At least my recollection is he did.
All I said it, didn't I say it now?
Well, we're all clear and we're all on the same page. But right. So yes. And another point to bear in mind is that, of course, a preference shareholding position in the waterfall would rank the notes below all debt. And it wouldn't rank the notes above the notional holders. So, I'm sorry, forgive me if I'm repeating myself. So as I've indicated, you have to look elsewhere. Another point that arose was the relevance of insolvency inside and outside, the relevance of subordination inside and outside of an insolvency. And it is relevant because, and those provisions are not in there for no reason. What you have got outside of an insolvency is you have got conditions that would enable the issuer to repay some of the subordinated debt. And in order to pay the subordinated debt outside of an insolvency, you have to be solvent. In other words, and the way we would construe it, and I'm simplifying it slightly, we would construe it is you have to be able to pay the senior creditors. You have to be able to pay the senior creditors, and if you can pay, and there are two things that you need to be able to pay. You have to be able to pay your debts as they fall due, and you have to your assets have to exceed your liabilities, other than those that are not senior creditors. Now, for the purpose of this, let me just go with my learned friend split. You've got our point about the brackets applying to both. Let's just take it for a minute that it was debt. The one thing my learned friend, so outside of an insolvency, you have to be able to do both of those things in order to repay your subordinated debt. And it matters which subordinated debt you have to be able to repay, because the second of these, even on my learned friend's construction, is assets exceed its liabilities other than the liabilities of people who are not senior. So those who you have to be able to pay turns on who is senior to the subordinated debt in question. And that applies outside and inside. So it identifies which subordinated debt you can repay, and it matters. And a senior subordinated debt can be paid before a more junior debt. And of course, on the face of the judge's decision, the notes could be repaid before the debt when Lehman's. The notes could be repaid before the debt when Lehman's was solvent, if it passed the solvency test. These notes, the 6 billion worth of notes, could be repaid, but the debt couldn't. And then once you get to insolvency...
Sorry, just say that again. On the judge's judgment, the notes...
On the judge's judgment, the notes were senior to the debt prior to insolvency. So if you were to look at the debt's solvency condition, because they've all got these solvency conditions, you'd have to be able to pay the notes before you could pay any of the debt on the judge's decision. I'm sorry, am I doing this?
I thought it was the other way around. Right?
Sorry, the judge's decision. The judge's decision before insolvency was that the notes were senior to the debt. Sorry, it was just one of those horrible moments. So the judge's decision
before amendment.
Yes, but I'm no, not before amendment. Well, outside amendment, because it's outside of an insolvency. So, I mean, in a solvent situation, Lehman's hasn't gone bust, and it has got 6 billion worth of sub-notes, and it's got all this sub-debt. And the effect of the solvency condition that you find in the sub-debt is that you have to be able to pay the sub-notes before you pay the sub-debt.
Right. Can you just give me a cross-reference to the judge's judgment? Well, you don't need to do it now. Perhaps you can come back with it tomorrow morning.
As to, yes.
Where he discusses this point.
No, well, no, he doesn't explain this point.
Oh, I see.
I'm explaining this as a consequence.
Oh, I see.
Because my learned friend said it didn't matter outside of an insolvency. That's just plain wrong. Because outside of an insolvency, the relative subordination determines who the company can pay first. So if Lehman's had wanted to redeem some of its subordinated debt before an insolvency, Lehman's would have to have repaid the notes before the debt. And that is because the solvency condition, assuming the judge is right that it was senior, of course, but then one gets into the solvency condition in the notes, which for your notes is on 679. And it says the borrower shall be solvent if it's able to pay its liabilities other than subordinated liabilities disregarding excluded. So if the notes were senior, which on the judge's analysis before insolvency they were, they have to be paid before you can pay anything on the notes. You then go into an insolvency.
Sorry,
I'm sorry, my lord.
I'm getting lost here.
Okay.
The issue is solvent if it's able to pay its debts as they fall due.
No, you're looking at the wrong solvency condition. I'm going to come back to debts.
Well, the judge said you have to satisfy both.
Yes, I'm looking at the solvency condition in the sub-debt.
In that case, I'm looking at entirely the wrong document.
I'm so sorry. I'm doing it too quickly, and it's one of the. Could your lordship turn to tab 38 of page
Yes.
79, and then I will go back to the other definition, my lordship.
Right.
We'll do that. Okay.
So we're looking at the solvency condition
In the sub-debt.
in a sub-debt. Right.
So the borrower shall be solvent if it is able to pay its liabilities other than the subordinated liabilities in full, disregarding the excluded. So that's at the top of the page in little 2. So prior to an insolvency, if the notes are senior to the debt, what that means is that the notes have to be payable before anything could be paid on the notes. And the point that I was just dealing with is it does matter before an insolvency. It doesn't only arise when Lehman's goes bust. Because one thing that you've seen is that they did from time to time pay back or issue their regulatory capital. And it was affected prior to insolvency by the priorities. And that's one of the reasons why it's very simple in this case to just look at it and think this only arises in an insolvency. It's only when Lehman's goes bust that it matters. And that's not, and therefore to just look at what the ranking is under the amended notes and say, well, that's what the ranking is, and it doesn't matter. It does matter. And that's why when I said to your lordships that a position where the notes are senior before an insolvency, but are then junior after an insolvency, is commercially at least highly surprising. And I would respectfully submit that your lordship should have that in mind when your lordships are construing these provisions. So that was just looking at the relevance before, but I know, my lord, that you would like me to go back now to, if we can go forward to tab 42.
No, I was just looking at the wrong document. So
No. My lord, I can't pretend that my points are in any logical, necessarily in a logical order. So why don't we look at this?
Sorry, you're now going to?
I'm now going
42.
back to the solvency condition in the sub-notes. And I was, which your lordships will find at 42 at 742 at the top of the page.
Yeah.
Because as you know, that there are two parts, 1 and 2, to the solvency condition. And one is being able to pay its debts as they fall due, and I'll come back to that. And the second is the assets exceed its liabilities as defined. Now you've had our submission on the effect of the brackets applying to both, and this only making sense if it is senior debt. The words my learned friend did not draw attention to, and this is important, is able to pay its debts as they fall due. Because the submission that's being made is that the effect of that is that you have to be able to pay all debts. And the effect of that is to make the notes junior to all other debt. It is only debts as they fall due. And the argument depends on its debts, including junior debts, and it depends on junior debts falling due at the time that this is looked at. And we just looked at a junior debt, and we saw that it can only fall due if the senior debt can all be paid. So it is not as simple as my learned friend suggested, because that junior debt will not fall due according to that condition that I just showed you in the sub-debt, the solvency condition in the sub-debt. It will not fall due for so long as the senior debt has not been paid. So my learned friend's submission that on the back of is able to pay its debts, and he didn't go on to the rest, that this subordinates the notes to all the debts, is just not right. And when you read that in the context of the rest of the clause, as I respectfully submitted yesterday, it refers to senior debt. Not only because this debt is subordinated to senior debt, but also because the junior debt is not going to be due until and unless the senior debt has been or can be paid. I hope I didn't make that.
No, I understand that. If the payment's under the notes not due, then the notes are within lim 2 and not lim 1.
Exactly, and so we don't fall underneath. That submission is not right. Sorry, forgive me. Yes, can I just make a couple of points in relation to Mr. Grant's description of the subordination? Where's paragraph 52? What was it? Sorry, forgive me. Oh yes, sorry. Thank you to my learned junior, Mr. Wilson. Yes, and my learned friend did not sufficiently address the points that we made yesterday. That if the subnotes contemplate that they will sit above other junior debt, which you've seen that they do, then the same clause cannot put the notes at the bottom of the waterfall. And in our submission, the point that my learned friend made, which is, well, there was no junior debt, don't worry about it. I'm sorry, but that doesn't deal with a point of construction. When we're construing this, we have to construe it on the basis that there is or there may be. Yeah, and then just one final point. It's the same with the excluded liabilities. You've got reference to excluded liabilities. The fact that there weren't any doesn't mean that one doesn't construe what that might be. I said I was going to look at Mr. Grant's description of the subordination. Mr. Grant's evidence is in A1 at paragraph 2. And my learned friend took you to paragraph 52.
Just a minute.
I'm sorry.
Supplementary 1, tab 1.
Supplementary 1, tab 1, page 19.
Page 19. Yep.
Yes. And with respect to my learned friend, I don't want to pick about this, but he didn't read all of it. So I want to take you through all of what he said. Following the amendments, in a winding up, the note holders were still described as ranking below senior creditors. And I think that's the passage my learned friend skipped over. But in place of the solvency condition, they were also described as ranking above all classes of issued shares, including ordinary and preferential shares, and above the notional holders up tier 2 security. Whereas before the amendments, the conditions only described what ranked above the LBHO2 subnotes. The amended conditions describe what ranks above the subnotes and what ranks below them. And my learned friend said, there you are, it shows that Mr. Grant was telling you that the solvency condition identified a ceiling and a floor. What my learned friend did not show your lordships is the ceiling that is in that paragraph. Because the ceiling that is in that paragraph...
Sorry, why are we looking at this paragraph?
Oh, I'm dealing with a specific point on the evidence that was made by my learned friend.
Are you saying this is relevant to the interpretation of the subnotes?
No.
So it's got nothing to do with interpretation. So why are we looking at it?
Well, this was a point that was made on rectification. Just give me one.
Well, that's fine. I understand that. So are we moving to rectification now?
Yes, I'll just check if I may with my notes that I didn't have anything else. Oh, okay. I'm going to do this from here. And you haven't got this. Now I'm going to turn to rectification.
Right.
I don't think I have any other points, but if I do on construction, I'll come back to them tomorrow morning.
As long as I know where we are. So we're going to rectification, in which case, of course, Mr. Grant's evidence is relevant.
Absolutely. And actually, before I do that, I've just got a couple of... I want to do some different points before I do that. I'm sorry. The first thing that I wanted just to remind your lordships, because a lot has been said about what we were asking for in terms of rectification, but it is in core bundle 2 at tab 32.
Yeah, it's in your position paper, I think.
Oh, your lordship's got it. Your lordship's got it. Okay, I just wanted there to be clarity in relation.
No, yes. I mean, normally you look for a pleading, but the position paper's as close as we get.
My lord, may I say something about the position paper? Because they are not pleadings. They are a sort of modus operandi that developed in Lehman's. And when I came to this matter, there was already this modus operandi. And all I will say is that they have never been treated like pleadings, which is lucky for my learned friend, Mr. Beltrami, because the argument that he ran on conditionality wasn't the argument in the position paper.
Well, I'm not quite sure what I've only ever come across them actually in family cases before, position papers.
Well, my lord, you have an advantage over me. But anyway, be that as it may. Going to substance. My learned friend, towards the end of his submissions, and I think it was in his point 4, he said that the rectification case should have been to include a statement that the amendments didn't affect the ranking, or words to that effect. I don't have that quite clearly. But with respect, that is precisely what the confirmatory note does in this clause. It's precisely what it does, and your lordships have heard the submissions on that. Now, if such language is sufficient to direct the way in which this should be interpreted, then I'm the first to say great. That is a construction point. My learned friend then talked about clause 12a, and if I may just say a few words about clause 12a. Your lordships have seen it is a mechanism for the amendment of certain reserved matters. And those certain reserved matters included altering the date for payment of interest. And of course, one of the reasons for that, and I'm doing this as a matter of construction, one of the reasons for that is that those reserved matters are important matters that required not just the sort of amendments my learned friend identified in 12b, more important matters, so they are reserved and they require the assent of the shareholders through the mechanism in 12b. It is a proposal by the issuer, and my learned friend said the issuer has to agree. Well, the issuer is the one who proposes it. This mechanism isn't an offer and acceptance type mechanism. It is a proposal and accord mechanism. And of course, any party proposing a mechanism is doing so on the basis that that's what they want to do. And you don't need anything more than a proposal. And there is a mechanism for note holders to assent to those proposals. It could be 2/3, it could be 1/3, it could be 100%, which, as you know, is what happened here, but is still assent by extraordinary resolution. And in our submission, that is no different to the pension cases because it's a mechanism.
Your reliance on clause 12, as I understand it, is to say, well, we don't need an outward expression of accord as you would normally need in a rectification case. is clause 12 wide enough to apply this mechanism to a change in relative ranking?
I'm looking at the clocks and I'm wondering if I really ought to check.
Well, you may want to, because what I'm curious about is,
Yeah.
if the particular change, let us assume that you're wrong about construction, and the particular change was a change in the ranking, if it is outside the scope of clause 12, does that still mean you don't need the outward expression of accord? I think in AMP and Barker, the change was within the scope of the power.
Yeah, but no, I can answer. What was the consequence? So forgive me.
Well, you can come back to this tomorrow, Mr. Phillips. As you know, we've made up quite a lot of time.
If I may, because I really do want, I think the answer to the question.
Oh, do you understand the question that I'm putting to you?
It is on the transcript. What I want, you may want to just what I'm ranking outside the scale. Does that mean? Oh, I see. So the question your lordship is asking is, if it's outside the scope of this mechanism, do you need agreement?
Yeah, does clause 12 still remove the need for an outward accord? I understand the argument. If it's within the scope of clause 12, then you say, well, that's the mechanism, you don't need anything else. But if it's not within the scope of clause 12, what then?
I think the answer to your lordship's question is yes, because it's modification by extraordinary resolution. There are then reserved matters, but I think modification as a general matter. But I'll come back and answer.
I mean, if clause 12 extends to any conceivable modification, then that's your answer. But
yes.
Yeah.
Let me check. That I think is the answer.
All right.
But I'll check.
All right. Well, then let's stop there and sit again tomorrow at 10:30.
Thank you.